Hello everyone. Good evening, namaste, namaskar, assalamu alaikum and vanakkam. Friends, is my audio clear? Am I visible to you all? Friends, hello. Hello everyone. Am I visible to you all? Is my audio clear? Hello. Yes. Yes. Okay. Friends, as part of our video lecture, today we will be discussing the principles of fair trial as under the Code of Criminal Procedure 1908. Friends, if you want to compete with thousands of aspirants and to stand out from the crowd, get Unacademy Judiciary subscription today. Friends, today is a special day here with the name of Unbox 2021. If you purchase 1 year plus subscription for Unacademy Judiciary, you will get absolutely 6 months subscription free. This is valid only for 1 day. Friends, you can also use the code SUBHANLIVE SUBHANLIVE in order to get this offer. Therefore, friends, just purchase 1 month subscription and get 6 months subscription absolutely free. This offer is available. This Unbox 2021 offer is available and it is valid only for 1 day. Therefore, friends, unbox your true potential with extra learning time by purchasing 1 month plus subscription and get 6 months subscription absolutely free. Friends, this is a special week for Unacademy Judiciary. In this week, you will be charged a special price. It is now or never. Just avail these exciting offers, save 15% etc., and additional 10% of offer on using my referral code for your judiciary examination subscription. Therefore, friends, you can use this code now. You can use this code SUBHANLIVE SUBHANLIVE. Friends, only this offer is valid only for today. Okay, get plus subscription for 1 year and get 6 months subscription absolutely free. Okay, absolutely free, friends. You can also use the code SUBHANLIVE SUBHANLIVE in order to get 10% of offer. This offer is valid only for 1 day, that is today, that is 10th December at 12 AM. Okay, why are you waiting for, friends? Okay, unbox your true potential with extra learning time. Friends, this is the special price week for Unacademy Judiciary subscribers. Apart from additional 10% of offer using this code, you will also can save 15% of the subscription fee if you get a subscription of Unacademy Judiciary during this week. Friends, these are the special prices. 6 months, this is the actual price. This is the offered price for 12 months. For iconic subscription type, this is the actual price, but now this is the special price. For 24 months, this is the for iconic subscription, this is the actual price, but this is the special price. Friends, for plus subscription, this is the actual price for 6 months, and you will be charged just this amount if you get subscription this week. This offer is ending very soon. Therefore, for 12 months, you will be charged just this amount, but not this one. Okay, for 18 months subscription, you will be charged just this one, but not this one. For 24 months of subscription, will be charged just this amount, but not this amount. Friends, this offer is valid only from 19th December 2021 to 15th December 2021. This offer is valid only for this week. Therefore, it is now or never. Avail these exciting offers of Unacademy Judiciary. Principles of fair trial. Friends, the concept of principles of fair trial is conducted as per the principles enumerated under CrPC in various sections of law, in various chapters. Now, friends, in today's class, we will be discussing what are the principles for conduction of fair, just, and reasonable bail. Sorry, reasonable trial, not bail, for trial. Now, friends, in India, the criminal procedure follows the adversary system. Okay, the adversary system. A fair opportunity will be given to the accused. Okay, accused can engage an advocate. His version can be submitted to the court. Then prosecution will submit their own version. Finally, the judge will make a decision. Good evening, Preeti Rajakji. Good evening, very good evening. Now we are discussing principles of fair trial in today's class. Okay. The first principle is presumption of innocence of accused. Let us count all these. Presumption of innocence of the accused. Okay. In Indian criminal procedure, the court always presumes that accused is an innocent. Therefore, the burden always lies upon the prosecution in order to show the guiltiness of the accused. Okay. If the prosecution fails to prove the wrong committed or the offense committed by the accused, even with a chain of events, if there is a break in proving those chain of events, then in the benefit of doubt, the accused may be released. Therefore, Indian law, especially Indian criminal law, presumes that accused is always innocent. Prosecution has to prove their own case. Prosecution has to prove the accusations made against the innocent accused person. This is the first one. The Indian Criminal Procedure Code, that is the Criminal Procedure Code enacted by the Government of India, says that the trial must be conducted by an independent, impartial, and competent judiciary. Therefore, friends, the judiciary must be competent. The principle of no man shall be a judge for his own cause is up. Therefore, the judge must be independent, he is neutral, he is impartial, he never shows any favoritism or nepotism towards any party to a particular criminal case. He never support the accused, he never support the prosecution. He decides the case very neutrally, impartially, independently, without influence of any other extraneous forces. Therefore, friends, the judiciary must be also competent also. Therefore, competent okay, independent and impartial judiciary. Has to conduct a fair trial. Therefore, the same is followed here. Now, according to section 177 of CrPC, okay, section 177 of CrPC very clearly states about the venue of the trial, where the trial has to be conducted. According to section 177 of CrPC, the trial has to be conducted at the place of offense, at the place of alleged offense. If the prosecution makes any allegations against the accused as to the accused person has committed a particular crime, then the entire trial has to be conducted in a venue wherein such alleged offense has been committed or said to be committed. Therefore, friends, if a person is guilty of any offense, if a person has been arrested, if the accused person has been arrested in a particular place, then the trial has to be conducted in the same venue only, in the same place within whose jurisdiction the court shall entertain such cases. It is also one of the principles of fair trial as enumerated under section 177 of CrPC. Friends, whenever a person has been arrested, here the right of accused, the accused person has right to know the accusations made against him. Therefore, a copy of the FIR, a copy of the statement made by the other persons, a copy of charge sheet, everything will be supplied to him. Therefore, he has right to know about accusations made against him. Therefore, it is the another principle of fair trial. Then, one of the most important principles of fair trial under the Code of Criminal Procedure is that accused person should be tried in his presence only. Therefore, trial in the presence of the accused. Therefore, friends, audi alteram partem, the doctrine of audi alteram partem, which means that hear the other side, give an opportunity to hear the other side. This principle is applicable here. Every trial, if any witness has been examined, whether he is deposing in support of the accused or against the accused, it is immaterial. Whenever a witness has been examined during the course of trial, such examination, especially the examination in chief, the cross-examination or re-examination, must be done in the presence of accused. Only in the presence of accused, the trial has to be conducted. It is very clearly stated under CrPC. Now, evidence has to be taken in the presence of the accused. It is also very clearly stated. Therefore, all the evidences, evidence has to be taken in the presence of the accused person. It is also one of the important principles of fair trial as enumerated under the Code of Criminal Procedure. Friends, today is a special day, with the name of Unbox 2021. Unacademy Judiciary has been offering a special offer for Plus subscribers. If you purchase 1 month Plus subscription, you will get 6 months subscription absolutely free. You can also use the code SUBHANLIVE SUBHANLIVE in order to get 10% more of additional offer on your subscription amount. Okay, friends, the next principle is that right of the accused to speedy trial. Therefore, right to speedy trial. It is also one of the important principles. Here, the under trial prisoners cannot be put in the jails for years together. Therefore, he has every right to get the speedy trial or speedy disposal of the cases or accusations made against the accused person, friends. This is also one of the important principles of fair trial. Then, then right of the accused against double jeopardy. Okay, that is right against double jeopardy, which means that the accused person cannot be charged twice for the same offense. For instance, friends, a person has been arrested under the charge of theft. He cannot again arrested for the same offense. Okay, right against double jeopardy means that right against number of trials for commission of a single crime. Therefore, friends, an accused person shall not be tried more than once for the same offense. The accused person shall not be punished for more than once for only one offense. It is very clearly stated under the Code of Criminal Procedure. Friends, right of the accused person against right against incrimination. Self-incrimination. Therefore, friends, it is also one of the important principles to be followed at the time of fair trial, which is conducted by a competent, impartial and independent judiciary of India. Now, friends, it means that the accused person has a right against the self-incrimination. He cannot be put to several questions which will incriminate himself. The court cannot put him several questions which are self-harming to himself. Therefore, self-incrimination has to be avoided during the course of fair trial. Therefore, the accused person has every right against the self-incrimination. Along with these, friends, the accused person have a public trial. Therefore, it is also one of the right. Public trial. Here, friends, it means that the accused person the accused person has a right to public trial. Therefore, in the presence of the public, in the open court, the trial has to be conducted. Okay, it cannot be in a closed room. Trial cannot be conducted in a closed room. It should be conducted in a open court, the presence of the public. Then friends, in case of these principles, okay, these principles, in case of any kind of criminal cases, these principles have to be strictly followed by any court of justice in India. Now, then friends, then we need to know about a few important concepts. Okay, few important concepts which are related to the trial by various courts and its relevant sections here. Along with these, the trial by court of session, what kind of principles it follows, and thereafter the judgment in connected matters, how it should be taken into consideration while conducting a trial. Then warrant trial on a police report. Then thereafter the summary trial and summons trial, and the basic conceptualization of all these concepts has to be uh, discussed. It has to be discussed in today's class in a nutshell. Okay, now let us see these concepts, friends. Along with these concepts, we need to remember that according to Articles 10 and 11 of the Universal Declaration of Human Rights, in today's class, friends, it is a length. Let us see in brief what kind of steps are involved in the trial of a court of sessions. Okay, in sessions trial. It means that it is a trial, it is a fair trial conducted by a court of sessions. Now, the relevant sections of law or sections 225 to 236, section 311, 313 and 314, friends. These are the relevant sections of law with regard to sessions trial. Now, let us see various section of laws and their importance. Okay. Now, parties. Who are the parties to a fair trial? It is stated under section 225 of CrPC. Now, let us see the Bare Act, friends. Now, let us see the Bare Act. Please open your Bare Act and just go through section 225 of CrPC. Okay, section 225 of CrPC. Trial to be conducted by the public prosecutor. In every trial before a court of session, the prosecution shall be conducted by a public prosecutor. Therefore, friends, the trial has to be conducted by a public prosecutor. It is very clearly stated in this case. Therefore, prosecution has to conduct the trial according to section 225. Therefore, it is about who are the parties to conduct the trial, who has to start the trial. The trial has to be conducted by a public prosecutor. In every trial, it is very clear, friends, in every trial before a court of session, the prosecution shall be conducted by a public prosecutor. The prosecution shall be conducted by a public prosecutor. Therefore, the prosecution case has to be conducted by a public prosecutor. Sophia Sharpji, Preeti Rajakji, good evening, good evening. Now we are discussing principles of fair trial. Section 226 says that then opening of the case. Opening of the case. Who has to open the case? Prosecution has to open the case. Prosecution has to open the case. It is stated under section 226 of CrPC, friends. Thereafter, this is a stage 2 under sessions trial. The third stage is that discharge of accused. If there is no material is found to show that the accused person has committed a particular offense which is alleged by the prosecution, then if the prosecution fails to show any material particular or any document or any evidence in support of their accusations against the accused, then the court may discharge the accused. Therefore, discharge of the accused is the next stage. Discharge of the accused. Now it is enumerated under section 227 of CrPC. Friends, the fourth stage is framing of charge. The evidence collected by the prosecution is enough to show the prima facie case against the accused person, then the court will frame the charge. It is stated under section 228 subsection 1 of CrPC. Okay. Now the fifth stage is that after framing of the charge, the court has to explain the contents of the charge to the accused person. Therefore, explaining the charge to the accused is the next stage in a fair trial, as under explanation of charge to the accused. Friends, its relevant section of law is that section 228 subsection 2. Just go through this one. Thereafter, the sixth one, after explaining the charge to the accused, if the accused person pleads guiltiness, if the accused person pleads guiltiness, it is also known as plea of guilty. Okay, if he pleads guiltiness, then yes. If it is yes, then the court will convict him. Therefore, conviction. If he don't pleads any guiltiness, then a date will be given for prosecution's evidence. Then a date will be given for prosecution's evidence. A schedule will be prepared in accordance with the prosecution evidence. Then everything will run. Now, let us see, friends. Here, conviction on plea of guiltiness is explained under section 229 of CrPC. The prosecution's evidence, a date fixed for prosecution's evidence, is enumerated under section 330. Then, what will be the case of the prosecution? Now, let us see this one, friends. What will be the ingredients of evidence of prosecution? Evidence of prosecution. Under evidence of prosecution, the examination of the prosecution witnesses, all the prosecution witnesses, and record of evidence for the prosecution record of the evidence or the evidence, especially the examination in chief and cross-examination. Therefore, in the evidence of prosecution, examination and recording of the evidences, these are enumerated under section 231 subsection 1. It is related to examination of prosecution witness, examination of prosecution witnesses. Then under section 276 to 280 of under section 314, okay, arguments of the prosecution. Thereafter, examination of the accused, friends. After this one, after this stage, there will be an examination of accused. By the court, not by the prosecution, nor by the defense. Okay, examination of the accused by the court, friends. Then it is done in accordance with or as under section 312 subsection 1 class B of CrPC, friends. Thereafter, after hearing the parties, okay, and then order of acquittal to the accused person, this is enumerated under section 232, okay, 322. If the defense wants to produce any evidence, then the defense will produce the evidence. Examination of the defense witnesses is enumerated. This is the end of the case, friends. Okay, this is the end of the case. Acquittal of the accused based on the failure of the prosecution to prove their case. If the accused person or if the defense wants to produce their own witnesses, then there are some further more steps, friends. There will be further more steps. Let us jump to that point. Here, examination of the defense's witnesses, examination of defense witnesses. It is stated under section 233 subsection 1. Just go through this one, friends. Thereafter, after examination of the defense witnesses, there will be a written statement. It has to be submitted by the accused person. He has to give a written statement. He has to submit a written statement to the Honorable Court. It is enumerated under section 233 subsection 2 of CrPC. Then record of the evidence of the accused. It is well stated under sections 276 to 280, friends. These are related to record of evidence of defense of the defense. Okay. These are relevant sections. These are the relevant principles or procedures generally followed by the Court of Sessions in sessions trial. But these principles are applicable to all kinds of trials, friends. Even in case of sessions trial, in case of warrant trial, or in case of summary trials, or in case of summons trials, in all kinds of trials conducted in Indian courts, especially in criminal judicial system, these principles have to be followed. Presumption of innocence of the accused, competent, independent, impartial judiciary. Trial should be conducted by this kind of judiciary. Section 177 of CrPC, right to know the accusations made against a particular accused person. Trial to be conducted in the presence of the accused, evidence to be collected in the presence of the accused, right for speedy trial or right to speedy trial, right against double jeopardy, right against self-incrimination, and trial should be conducted in an open court in the presence of the public. These are the principles of fair trial. These are the relevant articles, friends. Article 10, 11 of United Nations Universal Declaration on Human Rights, and Articles 14, 20, 21 of Indian Constitution. These are exclusively dealing with this concept. Friends, with the name of Unbox 2021, Unacademy Judiciary is offering a special offer for Plus subscribers. If you get Plus subscription for 1 year or more, you will get 6 months subscription absolutely free. This is valid only for 1 day. You can also use the code SUBHANLIVE in order to get additional 10% of discount or offer on the plus subscription for 1 year or more than 1 year. This is valid. This is valid only for December 10th at 12 a.m. Okay, get subscription today and utilize this great opportunity. Apart from this, on 9th December 2021 to 15th December 2021, a special offer is available. You can save 50% along with additional 10% of offer using my referral code SUBHANLIVE SUBHANLIVE, friends. Therefore, 10% plus 15% saving, you will get 25% offer in this week, that is 9th December 2021 to 15th December 2021. Okay. Now we are discussing these concepts, friends. Now let us see the next one. Same in case of warrant trial on a police report, warrant trial otherwise than a police report. There are two tracks here. Now warrant trial. What are the steps involved in warrant trial? Warrant trial on a police report. On a police report. This one is warrant trial otherwise than a police report. Now let us see the friends. There is no difference in between the sessions trial and warrant trial on police report, except the differences in section of law. Therefore, similar friends, parties, thereafter opening of the case of the prosecution, okay, prosecution has to open the case. Thereafter, discharge of the accused. Just section of law are different. Thereafter, framing of charge. Okay. After this one, explaining the charge to the accused. Thereafter, friends, conviction on plea of guilty. Thereafter, date of prosecution. Prosecution evidence. Same procedure will be followed in case of warrant trial on a police report. But a warrant trial otherwise than Saurabh Sharma ji, Namaskar, Preeti Rajak ji, Sophia Sharp ji, Namaskar. Now we are discussing the principles of fair trial. Okay. Thereafter, friends, the summons trial. Okay. Summons trial. Friends, under summons trial, these are the relevant sections of law. They are sections 251 to 255, 259, thereafter 313, 314, and 274, and also 250 friends. Now let us see these the steps involved in the fair trial, especially in the style of summons trial. First, explaining the substance of accusation to the accused person. Therefore, explanation of the substance of accusation to the accused is the first step. The next one is that a conviction on plea of guilty. After explaining if he pleads guiltiness, there will be a conviction on plea of guilty. If he pleads guiltiness, there will be a conviction. The third step is conviction on plea of guilty in the absence of the accused in petty cases. Even in absence of petty cases, it is well stated under section 252 of CrPC. It's enumerated under section 251 friends. In petty cases, even in absence of accused, conviction can be given if he pleads guilty. It is well stated under section 253 of CrPC friends. If we don't feel any guiltiness, then hearing of the prosecution, hearing the prosecution under section 254. Thereafter, evidence for prosecution, then record of evidence of prosecution, all or enumerated under section 254 of CrPC friends. Thereafter, arguments on behalf of the prosecution, as under section 314. Now, the personal examination of the accused, here this one starts now. Personal examination. Personal examination of accused as under section 313. It is very clear, friends. It's very important section. Then hearing of the defense case. These are the steps involved in the summons trial. Okay. Hearing the defense, not of, hearing the defense. Thereafter, evidence of defense and arguments. Before this one, recording of the evidence of the defense. Then acquittal or conviction. And thereafter, compensation of accusation without reasonable cause. These are the relevant sections, friends. These are the relevant sections. 255. This is related to 254. This is related to 314. This are related to 254. Now, this is the procedure for conducting pre-trial fair trial in summons cases, friends, in summons cases. Now, this is about summons trial. In case of summary trial, there will be a separate and distinct procedure. Okay, due to the time constraint, today we are not going to discuss about those summary trials. Friends, I think you understood this concept. These are the principles of fair trial, presumption of innocence of accused, then competent and independent impartial judiciary. Thereafter, section 177 of CrPC, which speaks about place of trial or venue of trial. Thereafter, right to know the accusations, then trial in the presence of the accused and recording of the evidence in the presence of the accused, right to speedy trial, right against double jeopardy, right against self-incrimination, and right to conduct the trial in the open court in the presence of the public. These are enumerated under Articles 10 and 11 of United Nations Universal Declaration on Human Rights, and in Articles 14, 20 and 21 of Indian Constitution. These are the principles, and we have discussed briefly or in brief the steps involved in the fair trial in case of sessions trial, in case of the warrant trial on a police report, and in case of a warrant trial otherwise than a police report. These were the principles of fair trial as enumerated under the Code of Criminal Procedure. Friends, today is a special day for Unacademy Judiciary. With the name of Unbox 2020, Unacademy Judiciary has given a great opportunity for the learners. Friends, unbox your true potential with extra learning time. Get plus subscription for 1 year or more than 1 year, and get 6 months additional 6 months subscription absolutely free. You can also use the code SUBHANLIVE SUBHANLIVE in order to get this offer. This offer is valid only for 1 day, that is 10th December up to 12 a.m. Therefore, it is a great opportunity, friends. You can use this opportunity and subscribe Unacademy Judiciary. Apart from this, Unacademy Judiciary is offering special price for this week. This is known as special price week. This is known as special price week, friends. In this week, this special offer is valid from 9th December 2021 to 15th December 2021. These are the actual prices, and this is the special price. Now, with the additional, with 15% discount, these prices are available for every subscriber. Apart from this 15% discount, you will get additional 10% offer if you use my referral code SUBHANLIVE SUBHANLIVE. Friends, this offer is valid only for 1 week, that is 9th December 2021 to 15th December 2021. Okay, why are you waiting for? Get Unacademy subscription today, or get Unacademy subscription in the special price week, and it is now or never. Avail this exciting offer. Friends, if you want to crack the judiciary services examinations, use the code. Okay. Friends, Unacademy Judiciary has been conducting free special classes. These are the live classes, friends, conducted by the top educators of the country. These free live classes will cover Indian Contract Act, Civil Procedure Code, Jurisprudence, Criminal Procedure Code, Constitutional Law, Hindu Law, Muslim Law, Indian Evidence Act, Indian Penal Code, and all other local laws of your respective states. And some other laws are also taught by the top educators if your syllabus describes such law. Friends, the expert guidance for your Judiciary 2021 preparation is needed. The top educators of Unacademy Judiciary have curated detailed batch courses to provide you with everything you need to crack judiciary services examinations of your states. Friends, batch courses are already been started. A batch has been commenced on 7th July. One more batch has been started on 13th October. One more batch has been started on 27th October. Another batch has was commenced on 3rd November. Another batch was started on 17th November. Recently, on 1st December, a new batch has been started. Friends, it is a great opportunity. From 18th December, a new batch is going to start their lectures. This is known as Judiciary Mains Linking Batch. Okay, you can join in any of these batches and get Unacademy Judiciary subscription. Okay, crack your judiciary services examinations successfully. Friends, Judiciary Iconic. The name of Judiciary Iconic. Now, live doubt solving one-to-one live mentorship has been offered by Unacademy Judiciary. You can avail this opportunity. The live doubt solving is helpful for the learners to get personalized one-to-one doubt solving with the exam experts. Okay, this one-to-one live mentorship is helpful for you to get personalized expert guidance on your exam strategy and to get help whenever you are stuck. Friends, the mains focused test series is conducted by the mentors with the name of Judiciary Iconic. The mains answer writing practice test with evaluation by the experts. These are the special features. All the benefits of Plus will be available for the Judiciary Iconic. Therefore, friends, if you get Judiciary Iconic subscription, apart from the Plus subscription, you will get live doubt solving and one-to-one, one-is-to-one live mentorship. You get a personalized mentorship from Unacademy Judiciary, friends. Therefore, it is a great opportunity. Friends, these are the features of special classes. These classes are interactive live classes. You can attend the live classes. You can participate in the live chat. You will get your doubts cleared all during the live class. You can respond for the polls for better understanding of a topic. You can raise a hand. Plus subscribers even directly talk to the top educators in the live class, and you'll get your doubts resolved in the real time. You never miss any class, friends. You'll get notified for all the lessons, upcoming courses, and recommendations curated for you. The lecture notes also available. You can download the lecture notes and get access to recorded sessions of live classes. Revisit important topics whenever you need it for the same. Friends, anytime and anywhere, watch your live classes from anywhere using your electronic gadget like mobile phone. Thank you, Prashant Kumar Jain ji. Using your mobile phone, computer, laptop, etc. Friends, you can get the Plus subscription. If you purchase the Plus subscription of Unacademy Judiciary, you will get all the access to Plus subscription. You will get India's best educators. You will get interactive live classes. Live, you can take the live tests. You can participate in the live quizzes. You will get the structured courses and PDF notes, friends. Unacademy Judiciary is conducting T20 mock test series on the core subjects of judiciary on Monday to Friday in between 9 a.m. to 9:30 a.m. on the core subjects, especially IPC, CrPC, Evidence Act. Okay. On Monday, there will be a T20 mock test on IPC. On Tuesday, there will be a mock test on CrPC. On every Wednesday, there will be a mock test on CPC. On every Thursday, there will be a mock test on Evidence Act. Friends, on every Friday, there will be mixed bag series, so all the tests, all the subjects will be covered in this mixed bag series of T20 mock test on every Saturday and Sunday at 7 p.m. to 8 p.m. You will get the detailed analysis of all these tests conducted by Unacademy Judiciary. These were the special offers, friends. As we seen in the earlier slides, you can get the special additional 15% of offer this week from 9th to 15th. Okay, friends, you can also use the code SUBHANLIVE SUBHANLIVE in order to get 10% of offer plus subscription amount of Unacademy Judiciary. Friends, Unacademy Judiciary has started this Unacademy Judiciary YouTube channel, Unacademy Telegram channel. All my live classes are available on every Tuesday and Thursday at 9 p.m. to 10 p.m. Okay. Subscribe Unacademy Judiciary YouTube channel, like this video, share these videos. Okay, friends, join in Unacademy Telegram channel. Get all the updates regarding upcoming classes, upcoming courses, upcoming batches. Thank you very much for watching these videos. Stay tuned with Unacademy Judiciary. Thank you very much. Let us track it, friends. Friends, do you have any doubts? Prashant Kumar Jain ji and Saurabh Sharma ji, Sophia Sharp ji, Preeti Rajak ji, do you have any doubts? Friends, do you have any doubts? Friends, do you have any doubts?